Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a story here out of California. I honestly thought it was a hoax. Several people sent it to me. I looked it up. It's actually real. So California bill. This is a bill. It's not a law yet, but it's working its way through the California Assembly. And the California bill would let parents sue over their kids' social media addiction. So if you're a parent and your kid gets addicted to social media under this bill in California, the parents could then sue the company that is the basis of the social media. And some people might say, Steve, if you're a parent, shouldn't you be in control of your kids? Let's see. So parents may soon be able to sue companies like Facebook or Instagram, $25,000 per violation, and it's actually worse than that, but I'll explain. Stephanie Malott wrote the story for PCMag.com. Parents and guardians in California may soon be able to sue social media platforms for up to $25,000 under a bill that holds companies responsible for harming children who become addicted to those products. The Social Media Platform Duty to Children Act, introduced by State Assembly members Jordan Cunningham and Buffy Wicks, aims to prohibit social networks from causing addiction to young people by using or selling their personal data. But that's not all of it. It's actually broader than that. Addiction, according to the bill, relates to kids under 18 who are harmed physically, mentally, emotionally, developmentally, or materially by an obsession with services like Facebook and TikTok, but want to stop or reduce their use. The era of unfettered social experimentation on children is over, and we will protect the kids, says the bill's co-author from San Luis Obispo. The proposal only applies to companies that earned at least $100 million in gross revenues in the past year, which would be basically Facebook and Instagram, would not address email, would not address text messaging, would not address one-to-one oral communication services, AURL, oral, nor streaming sites like Netflix or Hulu, which don't feature user-generated content. Following approval in the California Assembly on Monday, the Social Media Platform Duty to Children Act now moves to the state Senate for hearings and negotiations. If approved, the bill will head to the governor's desk, and he could sign it into law effective January 1st. Companies that remove damaging features by April 1 or conduct regular audits and end practices deemed addictive won't be responsible for damages, in theory. Of course, it'll all have to get litigated. Not everyone is on board, though. TechNet, which is a bipartisan network of technology CEOs and senior executives, according to the AP, wrote a letter to lawmakers warning that under the statute, social media firms will likely just cease operations for children in California rather than face judicial consequences. And that is the obvious solution here. There's no social media company, let alone any business, that could tolerate that legal risk. So I went and looked it up because I honestly thought this might be a hoax or a joke or something. And it turns out it's real. And you can find it's quite easy to find the statute on the internet. You can actually go to the California Assembly homepage, and they have the bill listed, and its text, and its procedural history. It lets you know that it's already passed one house, it's going to the next one. And so, for instance, it defines addict. If you cause someone to become addicted, the verb there would be addict, and it means to knowingly or negligently cause or contribute to addiction through any act or omission or any combination of acts or omissions. So the lowest standard there is to addict somebody means to negligently contribute to addiction. So if your kid's on Facebook or one of these other ones, and you think the child is addicted there, you can sue if you can make out a case that the company negligently contributed to the addiction through any act. And it doesn't say a substantial contribution. And a lot of times the statutes will say things like that, meaning that something's got to be a substantial cause of something else. But to simply contribute means that the company may have done something that simply amounted to 1% of the cause of the child becoming addicted to the social media. Doesn't matter. That is a contribution. That is part of the cause. Therefore, it makes them liable. The statute then says after addict, an operator of a social media platform has a duty not to addict child users. Okay? Platform shall be found to have violated their duty if the social media platform is found to have addicted a child user by either of the following means. There's two things they could be doing that are wrong. One is the use or sale of a child user's personal data. Now, I'm not quite sure how, if Facebook sold your child's data, that would addict them to the platform. But I think they stuck that in there because most people go, but that is wrong. Of course it's wrong. They could just simply say it's illegal to sell the data of a child without their consent. And that would be the end of this. But no, they also said that platforms should be found to violate their duty if the social media platform is found to have addicted a child user by the development, design, implementation, or maintenance of a design feature or affordance, period. So, a person authorized to assert the legal rights of a child user who suffers injury as a result of a violation of this section may bring an action against a violator to recover or obtain any of the following relief. Actual damages. In a class action, the amount of damages awarded pursuant to the subparagraph shall not be less than $1,000 per member of the class. So there's a whole class of people. They can all sue as a class action and get a minimum of $1,000 per class member if they win. But also, a civil penalty of up to $25,000 per violation is available. And that's what the woman who wrote the article was talking about, but she missed the first part, which simply says actual damages. You could say your child suffered actual damages beyond $25,000. The $25,000 is simply a civil penalty that's been agreed upon as simply anybody who does this gets hit with this $25,000 civil penalty. But you can still get your actual damages, which are not capped. You can also get injunctive relief, where you can ask the court to force the social media platform to stop doing whatever it's doing that addicted your child. D, punitive damages. Again, the author of the article didn't mention these, but punitive damages, as you know, often exceed actual damages and often exceed civil penalties. So punitive damages are available. An award of the litigation costs and no more than twice the amount of reasonable attorney fees to a prevailing party. So despite the fact that in most cases you can't recover your attorney fees, here your attorney can double dip just to make sure this is nice and attractive to attorneys who want to take these cases. So an attorney can come in, spend $50,000 of his time on your case and get paid for $100,000. Well, you get actual damages, $25,000 civil penalty, injunctive relief, and punitive damages, which can be off the charts. Sure, why not? And any other relief that the court deems proper. So, if your child becomes addicted to social media, you can take their phone and go, okay, which platforms are you addicted to? And you discover that your child spends a lot of time on TikTok or Instagram or Facebook. And don't forget that they have to have that thing where they've got at least $100 million in gross revenue. And I'm not sure if all those platforms qualify. And yet, the important part is that all you've got to do is show that your child is addicted to the website and you believe that your child is addicted because of the development, design, implementation, or maintenance of a design feature or affordance on the website. They don't have to use or sell your personal data of your child to be liable here. All they've got to do is have used a development, a design, an implementation, or maintenance of a design, feature, or affordance which contributed to the addiction. So you could go into court and say, well, my child posts stuff on social media, and every time someone gives it a thumbs up or a heart or a like or whatever it is, they really get a rush out of that. And I've heard my child say, I've got a picture that's got so many likes on it. And then they put one up the next day that doesn't have so many likes. And they're disappointed. They're clearly addicted to social media. And what's doing it is that thumbs up, heart, like thingy. And so therefore, that's contributed to the addiction. And that is a development, design, implementation, maintenance of design, feature, or affordance that's causing this. Therefore, I'm going to file a lawsuit. I'm not going to do a class action because it sounds like you get less money per person, even though it's $1,000 a person. Some attorneys will want to do the class action because they'll make big money. But you can go to court and sue for actual damages. You can sue for the civil penalty of $25,000. You can ask for injunctive relief, where you can ask the court to order the social media platform to change how they conduct their business. You can ask for punitive damages. And obviously, if they make $100 million a year, it's going to be a big, big number to make them change their evil ways. And then, of course, you can get any other relief the court deems proper. So if this bill passes, which is halfway there right now, and gets sent to the governor and the governor signs it, what's going to happen very, very quickly is all of the social media platforms that used to be available to children will simply go, no more kids. Sorry, no more kids. You must be 18 years old to be on this platform, and there's going to be all kinds of check this box, click this box. And what's going to then happen is you're going to have kids who try to get around that by lying and saying that they're overage when they're not. And their parents are going to find out that they're on this platform because they're addicted. And because they're addicted to the platform should have realized that addicted children will go out of their way to get onto that platform. And so by failing to keep them off, guess what? Boom. You got all this stuff, your punitive damages, actual damages, double attorney fees. And I know right now it's very politically popular. And I don't mean politically in the sense of, there's an election coming up. But it does seem to be politically popular right now to attack social media sites, despite the fact everybody uses them. And I would urge you that if you don't like a social media site, you stop using it. And you might want to have a talk with your children about that. But, that's just my suggestion. But I've had people send me emails and messages and so on, and we've been discussing this. And I've had people say, Steve, I'm on this social media site, but what they're doing is wrong. And I go, then why are you there? And it's I have to liken this to the fact that I've mentioned before that there's certain stores I won't shop at. I don't care if they're the lowest price in town. I don't care. I make a statement by not shopping there. And I've had people actually contact me in the last month and say, Steve, do you understand that you make these videos that are 10, 15 minutes long? You could repurpose your videos into shorter videos and put them on TikTok. And you could get a big following on TikTok. I've actually had a guy every single day for the last 2 weeks send me samples of TikTok videos I could have made, where he takes my video, he cuts out a little section of it, puts a bunch of stuff all over to addict the kids, I guess, and then says, you could be doing this. And I say, I know. I don't want to do that. I'm not going to do that. I don't have a need to put my stuff on TikTok. And I've had people say, but Steve, do you know how many followers you could get? I don't care. I don't care how many followers I have on TikTok, because as of right now, I've got 0, and I'm happy. What about Instagram? Yes, I have an Instagram account. I don't post things there, almost never. I simply got it and parked it. But I don't post things there, and so I don't care. And the same guy said, you could take these things and post them on Instagram. I don't want to. No, I'm not going to. So you don't have to be on social media. And I actually know some people who are not. I literally know people close to me who don't do social media. And you talk to them about, they're like, what are you talking about? Face what? They don't know what you're talking about. So you don't have to be on social media. Your kid doesn't have to be on social media. And if your kid becomes addicted to anything under your roof, I would suggest that perhaps you should take a look at that first. But I don't know about passing a law to force a $100 million corporation to change its entire operation because your kid who's 17 years, 11 months old was addicted to social media, and that social media company contributed to the addiction. Didn't cause it entirely, just contributed to it. So it's a weird story, and it's a crazy case. Like I said, I thought it was a hoax. I really did. Sean and Bill both sent it, so thanks a lot. And it's from PCMag.com. Stephanie Malott wrote it. California bill would let parents sue over their kids' social media addiction, and that is suing the companies like Facebook or Instagram for damages, punitive and otherwise. for their children's addiction to social media. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I thought I'd wrap this up by reading a poem by Shakespeare, but then I thought, why should I? He never reads any of mine.